Hello everyone. In this presentation, an attempt would be made to explain the general exceptions that are contained in Chapter 3 of the Bharatiya Nyaya Sanhita. When a person is charged with the commission of an offense and prosecuted for the same, he can claim immunity from punishment by bringing his case within one of the general defenses that are contained in Chapter 3 of the Bharatiya Nyaya Sanhita entitled General Exceptions, which consists of 31 sections running from section 14 to section 44. These defenses can be pleaded not only in the case of offenses under the Sanhita, but also for offenses under special and local laws. These provisions deal with two classes of acts which have been exempted. One, excusable acts, and two, justifiable acts. In the first category, those cases have been grouped where there is lack of mens rea on the part of the person committing the act, either by reason of mistake as to the existence of a fact or by reason of the act being done accidentally or due to infancy, insanity, or intoxication. In the second category, those cases have been placed where the circumstances under which the act is committed furnishes legal justification, like judicial acts, acts done due to necessity, under duress, in exercise of the right of private defense, etc. These defenses are similar to those contained in the Indian Penal Code, which has since been repealed. Defenses provided under the Indian Penal Code have been dealt with elaborately with examples and important cases in presentations 7 to 10 on criminal law. This presentation therefore discusses very briefly the essential elements of some of the important defenses as contained in sections 14 to 44 of the Sanhita. In a criminal prosecution, the accused is presumed to be innocent. It is the duty of the prosecution to prove the guilt of the accused beyond reasonable doubt. When the accused relies on any of the general exceptions under the Sanhita, or under any special exception or proviso contained in any other part of the Sanhita, or under any special or local law defining any offense, Section 108 of the Bharatiya Sakshya Adhiniyam, that is the Evidence Act, raises a presumption against the accused and throws the burden on him to rebut the presumption. However, the burden is no higher than that which rests upon a party to civil proceedings, that is, on balance of probabilities or on preponderance of probabilities. The first defense is mistake. The common law principle, ignorance of fact is an excuse and ignorance of law is no excuse, has been embodied in sections 14 and 17 of the Sanhita. According to section 14, nothing is an offense which is done by a person who is bound by law to do it, or who by reason of mistake of fact and not by reason of mistake of law believes in good faith that he is bound by law to do it. According to section 17, nothing is an offense which is done by a person who is justified by law to do the act, or who by reason of mistake of fact and not by reason of mistake of law believes in good faith that he is justified by law to do it. Section 211 of the Sanhita defines good faith in the following words. Nothing is said to be done or believed to be done in good faith, which is done or believed without due care and attention. The justification for granting exemption from criminal liability on the ground of a mistake of fact is based on the principle that a man who is mistaken about the existence of a fact cannot form the necessary intention required to constitute a crime and is therefore not responsible in law for his deeds. Coming to judicial acts, sections 15 and 16 of the Sanhita grant immunity to judges and to those who carry out their orders from criminal prosecution. Section 15 extends protection to a judge with respect to acts done by him in discharge of his duty. A judge is protected from criminal prosecution even if he exceeds the jurisdiction granted to him by law and prosecutes a man for committing the alleged offense, provided it was done in good faith, that is, with due care and attention. But the privilege does not extend to acts of a judge who knowingly exceeds his authority or does something contrary to law. Section 16 grants protection to officers acting under the authority or order of a court of law. An officer is exempted from criminal prosecution even if the court issuing the order had no jurisdiction or the order happened to be erroneous if he believes in good faith that the order was lawful. Section 18 of the Sanhita negates criminal liability with respect to accidental acts. The section says that a man is not criminally responsible for unintended and unknown consequences of his lawful act performed in a lawful manner by lawful means with proper care and caution. It means that an act is not criminal if it is done without any criminal intention or knowledge, merely by reason of any harm which it might cause accidentally to any person. Section 19 of the Sanhita incorporates the doctrine of necessity as a defense to a criminal charge. Necessity means a situation where conduct promotes some value higher than the value of literal compliance with the law. It is on the principle of expediency that the law has recognized necessity as an excuse in criminal cases. In other words, necessity knows no law, and what necessity forces, it justifies. Section 19 stresses three conditions in order to claim exemption from responsibility. 1. The act must have been committed in order to avoid other harm. 2. The harm to be avoided must be such as to justify the risk of doing an act likely to cause harm. And 3. The act must have been committed in good faith without any criminal intention to cause harm. Sections 20 and 21 give protection to a child under a particular age from criminal prosecution and punishment. This is based on the principle that an infant is incapable of distinguishing between right and wrong, and so no criminal responsibility could be fastened in regard to his deeds. Section 20 grants absolute immunity to a child below 7 years of age on the ground that such a child is incapable of doing a criminal act. A child under such age group cannot form the necessary intention to commit a crime. Section 21 provides qualified immunity to a child above 7 years of age and below 12 years of age, if it is shown that the child has not attained the requisite degree of understanding to judge the nature and consequences of his conduct. He is exempted from criminal liability. In the absence of such proof, a child above 7 years of age is as such liable for his criminal act as an adult is. The maturity of understanding can be inferred from the nature and quality of the act, subsequent conduct of the doer, and other allied factors. Section 22 states that unsoundness of mind is a defense to a criminal charge. Unsoundness of mind has to be accepted as a defense on the ground that one who is insane has no mind and hence cannot have necessary mens rea to commit a crime. The act of an insane man being unintentional and involuntary, no court can correct him by way of punishment. The Criminal Procedure Code therefore provides for detention and care of such persons in lunatic asylums. Section 22 embodies two different mental conditions in order to claim exemption from criminal liability on the ground of unsoundness of mind. It has to be shown that the accused was incapable of knowing the nature of the act owing to unsoundness of mind, or that the accused was precluded by reason of unsoundness of mind from understanding that what he was doing was either wrong or contrary to law. The first case covers two situations, namely involuntary actions and mistakes of fact on account of unsoundness of mind. The second case covers those situations where a man, by reason of delusion, is unable to appreciate the distinction between right and wrong. So far as the defense of intoxication is concerned, it is contained under sections 23 and 24. Section 23 gives the same immunity to a man intoxicated involuntarily as Section 22 gives to a man of an unsound mind. A man, in order to claim exemption from criminal liability on the ground of involuntary drunkenness, must establish that he was incapable of knowing the nature of the act, that he was doing what was either wrong or contrary to law, and that the thing which intoxicated him was given to him without his knowledge or against his will. In such cases, the man intoxicated may not be said to have acted on his own accord and therefore is not responsible for the consequences of his act. Section 24 deals with that class of cases where a man gets intoxicated voluntarily. It imputes the same knowledge to such a man as he would have had if he had not been intoxicated. The justification for punishment in such cases is based on the principle that intoxication is the result of the voluntary act of the accused and he must answer for it, although he might not have been capable of self-restraint at the time when the crime was committed. Consent can be pleaded as a defense to a criminal charge. The principle on which this defense rests is that if a man decides to suffer harm voluntarily, he cannot complain of it when it comes about. The circumstances under which the law recognizes consent as a defense and the circumstances under which consent cannot be accepted as a defense are laid down under sections 25 to 30 of the Samhita. A person making a communication in good faith for the benefit of the person to whom it is made would also be exempted from criminal liability for the consequences under section 31 of the Samhita. Section 32 exempts a man from criminal liability in respect of acts committed by him under compulsion or duress. The threat must be that of instant death to the person compelled to commit the offense, and the person so threatened should not have placed himself in that situation of his own accord. The defense will not be available for the offenses of murder and waging war against Government of India. Now, when the harm caused by an act is so negligible that a man of ordinary temper would not complain, the law will not take account of it according to section 33. But in case of socio-economic offenses, the courts are reluctant to allow the defense of trifles. The rules pertaining to right of private defense are contained in sections 34 to 44 of the Samhita. The law provides that when a person is suddenly faced with an attack to his person or property and immediate aid from the state machinery is not readily available, that person is entitled to defend himself and resist the attack by inflicting on the assailant any harm that is necessary for the purpose of defense. Section 34 of the Act gives statutory recognition to the right of private defense by enacting that nothing is an offense which is done in the exercise of the right of private defense. However, this right is not absolute and is subject to limitations contained in sections 37 to 43. Section 35 gives every man a right to use force against an assailant and to cause harm for the purpose of protecting his own body and the body of any other person against any offense affecting human body, and to defend his own property and property of any other person against theft, robbery, mischief or trespass or an attempt to commit any of these offenses. According to section 36, the right of private defense is also available against an offense committed by a person who, due to incapacity or misconception, might not be criminally liable for his act. According to section 37, there is no right of private defense against the act of a public servant or an act done on the direction of a public servant acting in good faith under the color of his office, though it may not be strictly justifiable by law unless there is an apprehension of death or grievous hurt by such act. The right of private defense is not available when there is time to have recourse to the protection of public authorities, and this right does not extend to the infliction of more harm than is necessary for the purpose of the defense. Section 38 declares that the right of private defense of body extends to the causing of death of the assailant if the offense which occasions the exercise of the right is an assault of any one of the descriptions enumerated in that section, which include apprehension of causing death, causing grievous hurt, committing rape or gratifying unnatural lust, kidnapping, abduction or wrongfully confining a person, which may reasonably cause an apprehension that the man may not be able to contact public authorities for help, or attempting to throw or administer acid likely to cause grievous hurt. Section 44 declares that where there is a reasonable apprehension of death from an assault and the person is so situated that he cannot effectively exercise the right of private defense without the risk of harm to an innocent person, the right of private defense extends to the running of that risk. The right of private defense of property extends to voluntarily causing the death of the assailant in cases of danger to property resulting from any of the offenses set out in section 41, namely robbery, housebreaking by night, mischief by fire to any building, tent or vessel used for the purpose of dwelling or custody of property, or theft, mischief or house trespass. Under such circumstances, as may reasonably cause the apprehension that death or grievous hurt may be caused. According to sections 39 and 42, in cases other than those mentioned in sections 38 and 41, the right of private defense of body and of property extends to the voluntary causing of any harm short of death to the assailant. Sections 40 and 43 declare that the right of private defense commences as soon as a reasonable apprehension of danger to human body or to property of himself or another person arises from an attempt or threat to commit the offense, though the offense may not have been committed. And the right comes to an end as soon as the threat of assault has ceased and the apprehension of danger has been removed. The continuance of the right of private defense depends upon the nature of the offense in question. In case of theft, the right continues till the offender has effected his retreat with the property. In case of robbery, it continues as long as the offender causes or attempts to cause death to any person, or hurt or wrongful restraint, or fear of instant death, grievous hurt, or wrongful restraint. In case of criminal trespass or mischief, the right continues so long as the accused continues in the commission of such offense. In the case of housebreaking by night, it continues so long as the housebreaking continues. This, in brief, is about the various defenses that can be pleaded for an offense under the Sanhita or under a special or a local law. Thank you.